Let's now move on to certain conditions. The privacy rule tells you that you will have to use this data only when needed, the minimal necessary standards, condition of participation. The same privacy rule also says for certain purposes you don't have to, it does not always require the patient's authorization. You can very well use the data. We are going to see when does a legal disclosure can be done. They have identified like 12 national purposes or public health purposes where the privacy rule need not be followed. In the sense like it allows, the privacy rule itself allows the use and disclosure of the PHI. First thing we all of us know, it could be for the required by law. When the law wants, say for example, now when the government wants, like tell me how much of COVID patients, we need to give the information of the patients who are affected with COVID. So first thing would be required by law. Second would be like public health activity. Now the government or the corporation will have to take measures. Say if a COVID infected patient is there, they will have to surround this particular locality or trespassing by other people. They cannot allow intrusion or no trespassing is allowed in such patients owing to the contagious or the contaminating nature of the viral illness. For legal activities and of course for health purposes also, the privacy rule states that you can very well use a PHI. The victims of abuse, neglect or domestic violence, the PHI can be used. In such cases, you don't have to get the authorization. Health oversight activities, as we saw like the supervisory activities or government wants to make certain decisions like oversight activities, definitely the PHI can be very well utilized. And for judicial and administrative proceedings, say for example, now a doctor has been given a summons to appear in a court. At that time, the physician will have to go to the court ducis tecum. So that says like the physician has to go to the court with the unaltered original medical records. That time he cannot say my PHI is there. No, it is something, there is an administrative and there is a judicial proceeding where the physician is acting as a witness. Or a lawsuit has been framed against a physician. In that case, he can very well he'll have to go with the medical records, including the entire PHI. For law enforcement purposes, the same way as we discussed, something that is being required by law. Next comes decedents. Who are decedents? Deceased persons or dead people, people who have died. So their close relatives, they'll have to know, right, what was the reason my relative or what was the reason that my father died, because I need to know those information. So in case of decedents or for those funeral services, then you don't have to maintain the actual rule of privacy law. Next comes cadaveric organ or eye donations. Then for research purposes, yes, doctors, if they want to, that's why I said like epidemiological research purpose. What is epidemiology? Studies of epidemics, diseases. A research person who's there with epidemiological research, they can very well go to the medical records of the patients who are affected with that, and they need to elicit the history, the symptoms and all that, the treatment and all that. So for research purposes also, they can very well use it. Then serious threat to health. Say for example with COVID, it's a serious threat to health, right? At such emergency times, the privacy rule need not be followed so stringently. Next comes essential government functions. What are all the government services that are being needed or the corporation municipal services, that time they'll have to release it. And for workers' comp. See, workers' comp is one type of insurance which actually deals with or it provides reimbursement to employees or to such conditions which have occurred in their place of work, in their workplace. The workers' comp also require the complete information that needs to be given for the reimbursement. For TPOs, which is third party operations, there is no need to have a written request for using the PHI. Some examples that we are going to see here is disclosure for treatment. Now the doctor is going to treat up a patient. So for he'll have to talk with the pathologist or he'll have to talk with the general surgeon or the anesthesiologist. So that disclosure is very well allowed, right? There is no need of a written request that needs to be made by the physician, because that is actually a coordination of care. Next would be like, you are going to share the information to your employer, because the employer needs information. He is going to sponsor you a group health insurance. The employee will be collecting all the details. Same way, sharing and collecting of information by the plans like Medicare. Insurance companies need to know the full information about the beneficiaries. In these cases, there is no need to have a written request. A covered entity may not use or disclose a PHI unless a privacy rule permits it or the individual authorizes in writing. So we saw in TPO, you don't have to have a written request.